Welcome everybody to today's BTO session by our social housing team on grievance and disciplinary matters, some of the challenges that face housing associations. There's three of us presenting today, myself and my colleagues Lynn, Richmond and Marion Davis. This is an interactive session, questions and answers, so if you're aware that the meeting is being recorded, we're happy to take questions throughout the presentation. Probably best if you do that during through the chat function. And as I say, it's a bite-sized session today. We're speaking for 30 minutes or so, including questions and answers. So fire your questions in on the chat function. And without further ado, I will just pass on to some of the introductions. So myself, I'm Carr. I head up our employment law team in BTO solicitors. I also sit as part of the social housing team along with Marion Davis and Lynn Richmond. Specialised in employment law for well over 20 years, advising employers and employees of all different sectors. Social housing sector is one of my particular niches, and I've been advising housing associations for 20 plus years. And I'll pass you over to my colleague Lynn Richmond for introductions.
Thanks, Caroline. Well, good afternoon, everybody. As Caroline said, I'm also a member of the social housing unit. I'm a partner in our data protection and IP team. And I don't have quite the same length of experience, I'm pleased to say. That's not too naughty of me saying. But I've been advising social housing clients and housing associations for a while now as well. We deal with all aspects of compliance, training, breaches, cybersecurity, and as we'll see later today, particularly subject access requests and requests for information as well under the FOI regime. So I'll pass over to Marion just to introduce herself before picking up again later.
Right, my name is Marion Davis. I'm a senior associate with BTO solicitors, and like Caroline, I have been advising housing associations for over 20 years now. As part of that, I have become a specialist in charity law because that is also an area that so many of the housing associations now operate. And I tend to get involved in these sort of issues when there's an overlap with governance matters, which there often is. So I look at governance and regulatory issues when they arise in these contexts. I think to start off the Q&A, I should push a question back to Caroline and ask her to start telling us about some of the challenges that employers face when handling grievances or disciplinary matters. Caroline.
Thanks, Marion. I think when we decided to do this kind of talk today, you know, when would you ever need an employment law, or a data protection law, and a governance law? Well, actually, a lot of employment law issues do straddle governance and data protection, so we thought this was an apt subject for discussion today. I tend to be the first port of call for clients when it's grievance or disciplinary issues within our business, for housing associations and for all different employer clients, but this focus today is on social housing clients and housing associations. And as I say, I tend to be the first port of call where a housing association gets a grievance or a disciplinary issue. And unless it's straightforward and the housing association is comfortable dealing with it, I tend to get a call to just be a second opinion on matters. You know, the housing association's often got a view on how it wants to deal with matters. But depending on depending on who has raised the grievance or who's involved in the disciplinary issue and how senior that person is or how serious the complaint is, will tend to dictate how often I'm contacted by the housing association. So from a sort of risk management point of view, I am port of call for a lot of housing association clients just to run things past. I do sit in a team of 8 employment lawyers, I should say, so it's often not just me, but you've got me today. So sometimes just this is what we've got a grievance, we've got a disciplinary issue, and can we just run it past you to make sure we're dealing with it in an appropriate fashion. We always have to be alive to the kind of regulatory, Scottish Housing Regulator input into matters, depending on the nature of the issues. So the challenges for housing associations can involve as I say, depending on who it is that's raised the grievance, for example, depending on how senior that person is, depending on the size of the organisation, and is the grievance about a colleague? Is it about multiple colleagues? Is it about an organisational issue? Is it about the director or senior officer? Is it about the board? And the answers to those questions will dictate how serious the issue could be, the procedure to be followed. Does the association have an appropriate procedure in place to deal with it? If it's a disciplinary issue, which is obviously when the employer has an issue with an employee, again, we'll often get a call to say, here's the allegation, or here's the issue. Can we proceed with a disciplinary hearing? Here's what we're thinking about doing. Here's how we're thinking about managing it. Here's how we think the seriousness of the issues are and where it might end up. And as I say, we're often asked to, from everything from drafting the letters to giving the committee and or the director or the manager advice about how best to deal with it, both from a timing point of view, from a management point of view, and ultimately with the aim of getting the right result for the housing association. Marion, you and I often become involved in these matters when the matter, that's whether it's a grievance or a disciplinary issue, may trigger the Scottish Housing Regulators notifiable events regime. You want to just come in relation to some of the triggers for notifiable events regime in dealing with grievances and disciplinary issues?
Absolutely. I was actually just refreshing my memory as to some of the examples in the notifiable events guidance this morning, and there are quite a few which might occur in a grievance or disciplinary context. The obvious ones that stand out immediately are if there's a serious complaint or allegation that involves your senior officer, your chief executive, or your director. But we have also seen serious complaints or allegations against board members, and equally that would, if your committee is involved in an allegation or a matter that arises, that is something the regulator wants to hear about. And allegation is all that's required, of course. It doesn't have to be proven. You may not believe that there's any real substance to what's going on, but an allegation is an allegation and it has to be considered seriously if it's raising serious points. Whistleblowing is another area that, again, is an immediate trigger of a notifiable event. But one of the things that, again, Caroline and I have both had to look at in this context is whether something actually constitutes whistleblowing or not, because someone doesn't have to come forward and say, I am a whistleblower, for that to be an issue. And sometimes some thought has to be put into whether what is being presented to an association actually requires you to trigger those provisions as well. And you shouldn't be placing that burden solely on the person raising an issue. So again, that can be quite a big one. But another one that perhaps is less immediately obvious, which I think is possibly worth sort of pointing out here, is that serious adverse media reports or social media interaction is something that the regulator wants to hear about. And sadly, particularly the use of social media is something that can really cut across what an association might otherwise be doing. So one can see that that could be something to be taken into consideration as well. So yes, we often do find ourselves having these kind of conversations with clients so that they can, be assured either that they've correctly identified something as notifiable, or that they're reasonable in not notifying if that's, if that's the conclusion reached. But the other thing that flows out of the notifiable events guidance is the fact that there are some things for which you're also required to have policies. And again, that's something that Caroline and I have both had to deal with. Caroline, would you want to comment on how policies affect what you're doing first before I say anything on that?
Sure, absolutely. I think back to basics from my point of view, every housing association I've dealt with, whether they're members of EVH or not, will have a grievance and disciplinary policy. So that's the one policy I would expect employers to have. They're required to have it by law in any event. So grievance or disciplinary, you know, there's a go-to policy for the employer and the employee to have a look at, to see from the employee's point of view, they want to raise a grievance, how do they do it? The grievance policy will set out what's to happen, and if it's a disciplinary issue, again, the employer will have set out their procedure, set out their stall as to what an employee can expect to happen if they are to be investigated for the purposes of a disciplinary process. Things become a little more complex, bluntly, when you get higher up the food chain. If it's a complaint about the director, for example, you know, the grievance policy might not specify what happens if it's a complaint about the grievance. And in terms of the regulator's guidance, an employer in this sector is expected to have a policy in place specifically to deal with the complaint about a director, because that's the Appendix 3 to the regulator's guidance on notifiable events, is how to handle a serious complaint against the director or chief executive. So some of the issues that Marion and I have had to look at for clients, and we're hearing that in the wider sector, that there are more grievances at play. I think just generally, not just in your sector, but in every sector, lots of grievances and lots more tribunal applications. So the employer needs to be careful that it's got a proper procedure in place. And I don't want to focus on the director level, but it is in certain organisations we have seen that there is no policy in place to deal with a complaint against the senior director. And of course, that only comes to light if, on the occasion that happens, and I get a call from a board member to say, how do we deal with it? We then have to look to put in place a procedure, whereas if the procedure was in place already, the association would know what to do and would be ready to deal with that situation. So we have put in place various procedures for various clients, just so that you're ready for it, and hopefully it never happens, but always better to be prepared. And the regulator certainly expects that to be in place on a just in case basis. But on the odd occasion where it does arise, a complaint against the director, you want to know that you've got a policy, you've thought about what you want to happen, because it's the first question I will ask you if you call me for advice about the situation, is do you have a procedure in place? And if the answer is no, it just sets us and you as an organisation back a little bit. And it's already a tense time if you've got a big complaint about somebody senior in your organisation. So that's one of our kind of messages from today, is make sure your procedures are in place and up to date. I think the other procedure we've looked at recently, Marion, and that's cutting to the chase at the very end of the situation, but in some situations, an organisation, housing association or otherwise, might want to settle something out. It's certainly not it's not my go-to. Certainly not of the view that an employer should simply throw money at a situation to try and resolve it. But you know, you need to have all the tools in the toolkit. And again, the regulator will expect an employer in the housing sector, social housing sector, to have a severance and settlement policy in place, so that you've got proper procedures in place for making that decision if you want to do it. It is by exception. It's always my view in relation to advising any employer client that you wouldn't just settle for the sake of it. But bluntly, as an organisation in the social housing world, if you don't have a policy to deal with it, it will be a criticism by the regulator if you do choose to settle something without the policy. So Marion, you and I have worked on quite a few policies. Do you want to come in on the policies?
Yes, I mean, I think it would be fair to say that, particularly in the area of grievances or disciplinary procedures that have proceeded to a point where an exit is being looked at, or a tribunal claim is coming forward, severance and settlement agreements have become a much bigger topic. And that's and we are doing much more policy review on that score than we have done in the past. And that all flows from that's happened over the last few years, and I would say it largely flows from the change to the regulatory framework that brought in requirements about severance and settlement that didn't exist prior to 2019. So the regulator is now got provisions in, it's in Regulatory Standard 5, if anyone's interested in that detail, that you can only make severance payments in line with a clear policy. And they again sensibly link that back to, you can't use that settlement agreement to stop someone from whistleblowing. So you can't limit accountability of the association itself, but you can still use these mechanisms, but you have to use them after proper consideration and following a policy. And I think one of the things that the sector is much more aware of now is that the regulator is going to keep an eye on that kind of thing. A settlement agreement is a notifiable event in and of itself. So you're going to have to, while it might be otherwise a confidential document, you're going to have to expose whatever settlement you are prepared to reach to the regulator, and you're going to have to be able to justify that. And that all flows from regulatory engagements where the regulator came to the conclusion that such approaches to managing employees had been misused. So you don't want to find yourself subject to similar criticism, effectively. But a lot of clients are unfortunately finding themselves in a situation where they only look at their policy position at the point that they're having to look at whether they need a policy or not because something's happened. And it's much better to have thought that through ahead of time and have the policy sitting waiting for use, and maybe never have to use it, rather than be scrabbling about looking for it when you've got an actual active issue. So it is something where we're keen to help clients make sure that that sort of issue is already covered. I think one of the other things that often comes up, and it might be worth passing a question over to Lynn at this point, is not only is it your sort of internal policy and procedural documentation that comes under scrutiny here, quite often an employee will raise subject access requests to look at information you hold about them, and that's where Lynn's expertise comes in. Lynn, do you want to talk about how an employee involved in these processes can get information and what they might get from the association?
Sure. Well, I'm sure everybody will be familiar with the concept of the subject access request and how it can be used to recover information. And more we're seeing that they're used in the context of a grievance or disciplinary action as a means of recovering information. There's not necessarily a genuine concern about how data is being processed. It's to get evidence for that process. And we're seeing that more and more. And obviously the Housing Association, while dealing with everything else that's ongoing at the same time, also has to deal with the subject access request. And depending on the nature of that request, it can be a big additional burden. Sometimes you will get, I want to see particular minutes or a particular set of emails. And at the other end of the scale, you might get, I want everything that you've got that has my name on it or I've ever featured in. So it can be quite a lot of additional work when you've got other things to think about as well. But just in terms of responding to that, we get a lot of people that are concerned about what they might be handing over to the employee, if it might prejudice their claim. So always have a think about what information they're entitled to. It is only personal data and it's only their personal data. And then have a think about what exemptions might apply as well. And I'm sure everybody will be familiar with the idea of redacting information that's either not their personal data or that contains the information relating to another person. And that can be quite a difficult process. And that's something that we get involved in a lot, on advising what they can and can't disclose and what the employee can and can't see. And it will very much depend on the circumstances, but we will often get requests for statements of other employees that have been given in an investigation process. People want to know what's being said about them and why allegations are being made and what they need to respond to. So that's a very common query for us. And we would always advise people to have a think about the duties that they owe to other staff as well. Has the people that have been giving the statements, have they been told that that statement is going to be given in confidence? And if it is, it's not something that you just want to then hand over in response to a subject access request. So have a think about that, but also legal advice that you've been given in this process. That's a very important aspect to consider, and obviously you might not want to, and I think you probably 9 times out of 10 wouldn't want to share that information with the individual. So generally speaking, although it might be their personal data, legal advice which you've received is exempt from a subject access request. That's one of the specific exemptions. If you've had legal advice from your legal advisor, even if it contains the personal data of the person making the request, you don't need to provide that to them. There is a distinction that's worth bearing in mind, though. It's legal advice, and it has to come from a professional legal advisor. So if you've received external advice, from example, some HR consultants or other external advisors, that won't necessarily be covered by the legal exemption. So just be wary of where the advice has come from and who has given it. But if the advice is exempt, that covers all sorts of advice. So if you've had one of us, Marion or Caroline, along to a board meeting and it's been recorded in minutes, that will also be exempt as well. So you can redact out that sort of information. So it's always worth it having a think about exactly what you've got and what you need to produce. Caroline mentioned earlier a severance policy, and it's worth bearing in mind that there's also an exemption in relation to information where you've recorded potential negotiations with the employee. So if you are considering making an offer, for example, in a kind of managed exit situation, and there's information relating to what agreement you might be willing to come to, again, you don't need to disclose that information. The employee isn't entitled to recover that in a subject access request. One of the queries that we also get is how do subject access requests interact with other information that you might share, for example, in relation to an external advisor or information that you have to provide to the regulator. And there are different rules for determining what information somebody who's made a subject access request gets and what you're entitled to share with your external HR consultant or SHR. And that's quite often a query we get when we work with Marion in terms of making those referrals to SHR. We haven't provided this to the employee, but can we provide it to SHR? So Marion, I don't know if you just want to say a little bit about the type of information that SHR might be looking for in this kind of context.
Absolutely. One of the things that often seems slightly almost off kilter is that the housing regulator may have more ability to see documents than the individual involved, because the legislation that the housing regulator operates under and the regulatory regime that they then work with you as housing associations under allows them to ask for pretty much anything you hold. And while there are some exemptions, those link more to information that would be held confidential in a court setting and a court of session style court setting, not necessarily just a tribunal. And so something that you might not be under any obligation to give to the individual in an employment tribunal, on the other side, you may still be obliged to give to the housing regulator. And in some ways, it's the point of that is that you are required to be transparent with your lead regulator. And one of the things that is also worth bearing in mind is that your lead regulator is also subject to both freedom of information and data protection legislation, and may also be recipient of requests for information from exactly the same people you get requests for information from, and they will hopefully use the same exemptions that you would expect to be used by the housing association when it comes to legal advice. For instance, you might share legal advice with the housing regulator to explain decision making at the association, but you wouldn't then expect either yourself or the regulator to pass that information on in response to some kind of request from the individual involved. So it can seem quite convoluted, but the regulator has a very different relationship with you, and very different regulatory expectations and legislation to back that up. So they can request information. If you don't then provide it, they do actually have statutory ways of requiring that information to be provided. And generally in the sector, it's my experience that housing associations seek to comply before any such more drastic action is required to be taken by the housing regulator. But we can certainly help you navigate through all of that should it become an issue. I think moving on from the sort of data aspects, I think sometimes it's maybe worth looking at, you know, how this then cycles back to Caroline. So a question that I think Caroline's often asked is, do you ever deal with the housing regulator when you're dealing with grievance and disciplinary issues?
Tend not to get involved, but often brief clients in relation to what they should or shouldn't say. And I think different housing associations have got different relationships with the regulator. Some are keen to be upfront and let them know about everything, and other clients can sometimes be a bit more reticent. But I'm of the view that if the association is following proper procedure and has taken decent legal advice, there should be no difficulty sharing that and telling the regulator what you're doing, why you're doing it, and to follow due process. I think the other matter that I'm often asked about, just circling back to discipline and grievance, you know, once you get over, if there are hurdles in the way, like subject access requests, lack of procedure, we can deal with all of that, but actually the employer still has to deal with the discipline and the grievance issues. And at the end of the day, our job as employment lawyers is to make sure that the association is protected as far as the governance side, data protection side, but really as far as the employment aspect is concerned, to make sure due process is followed and an appropriate decision is issued. We often input in relation to the process to make sure the committee or the staff members have guidance in relation to how to properly handle the grievance and or disciplinary issues, so that any outcome will stand the test of scrutiny, whether that's on appeal. Those of you who are EVH members will be aware of the GNC appeal against grievance or disciplinary, so we're always getting an eye to that to make sure outcome letters are robustly and properly worded, to make sure your position is defended, and ultimately to see that right through to if there's an employment tribunal application, to make sure the association's got the appropriate defence. And I think the other thing that comes into play, which we mentioned, the severance and settlement, like any other business, you are entitled to look at potentially resolving matters, however they arise, by way of protected conversations and settlement agreements, assuming you've got the policy in place to do that. And again, we're well used to guiding housing association clients and all of our clients through that process of scripting and dealing with the employees as far as protected conversations, again, to achieve the right outcome to protect the organisation. So that's, from my point of view, that's kind of start to finish, how I become involved, how you might need input from a governance lawyer on the constitutional and governance regulatory side of it, and how you might need input from data protection. And they have all of us in various cases where we have had to have input from 3 different teams to assist an organisation in relation to matters. I'm conscious I'm not seeing any questions in the chat, but if anybody wanted a quick question, we're happy to unmute yourself and take a question if you have any. And if not, I'm comfortable that we've covered the issues in this bite-sized topic, challenging discipline and grievance issues for housing associations. So I shall end there. If you have any topics that you want us to do so future webinars on, please let us know. We'd love to give you some further sessions that are of interest to the sector. If you let Marianne or any of the 3 of us know, obviously the usual, if you have any particular issues and advice you're looking for, you know where to come, to your BTO social housing team. And other than that, I'll end today's webinar and enjoy your lunch. Thank you very much.
Thanks, Caroline.
Thank you.
Thank you.
Bye.
Thank you. Thanks, everybody. That was really interesting.